Madam Secretary.
If you
and if you would be quiet, because I'm reclaiming my time, you are not following this court order. But let's focus on the court order, because this opinion also says that to facilitate, which the Supreme Court is requiring, is an active verb. It requires that steps be taken. What steps have you taken to return Mr. Abrego Garcia to allow him to get due process?
Abrego Garcia is in his home country.
What steps have you taken?
If your continued advocacy for him were to...
I'm not advocating for him. I'm advocating for a court order, Madam Secretary. The court order says that you must take steps to follow the court order. You are here under oath. What steps have you taken to return Mr. Abrego Garcia pursuant?
I now recognize Mr. Goldman for 5 minutes questioning.
Thank you, Mr. Chairman. I would like to go back to Mr. Kilmar Abrego Garcia's case, Madam Secretary. But my first question for you is a pretty simple one. It's basic civics. Which branch of government does the Constitution give the authority to interpret what the law is, the judiciary or the executive branch?
Sir, going forward, the interpretation of the law, you make the laws in this body. The judicial branch makes sure that they have integrity and they're applied properly to individuals.
So that, okay, so I'm just going to take that as the judiciary branch. Now, let's focus for a second on what the judiciary branch has said about this case. We know the Supreme Court has said 9-0 that, notwithstanding your statements under oath here today, that Mr. Kilmar Abrego Garcia was afforded due process. He was, in fact, not afforded due process, because then if he were, you would have seen the withholding order that did not permit him to be deported to El Salvador. Now, you allege, and I guess the Attorney General alleges, that he's a member of MS-13. That may very well be the case. And if he is, now that that is a foreign terrorist organization, certainly the immigration laws would allow him and in fact require him to be deported. I certainly would support that. But the problem that we have here is what you allege, what Ms. Green alleges, what the Attorney General alleges, is not the judiciary. You don't get to decide whether or not he is an MS-13 member. And you don't have to take my word for it, because Judge Wilkinson, a Fourth Circuit judge, very conservative, addressed this argument. He said, the government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident in its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. Will you commit right now to give Mr. Abrego Garcia that process where you can prove your allegation that he is a member of MS-13?
Congressman, that judge that you just quoted did not say he was not a member of MS-13. Who did say that he was a member of MS-13 was law enforcement officers that encountered this individual.
Yeah, he knows that. This is a Fourth Circuit judge. He knows all of what the evidence is, and he's saying if that evidence... So you're not going to commit to follow this order? You won't commit to follow this court order?
By the way, he identified
Madam Secretary, I reclaim my time. Stop filibustering. Stop filibustering.
By gang members of MS-13.
Will you give Mr. Abrego Garcia the due process that the Supreme Court and Judge Wilkinson has required you to give him?
Abrego Garcia is an El Salvador resident who is in his home country. If he were to come back to this country, he would be immediately removed again.
How do you know?
He has received and been treated appropriately,
sir,
and he is not.
How can you say he's been treated appropriately if the Supreme Court has ruled 9-0? 9-0 that he hasn't been treated appropriately? Why is your opinion better and have more authority than the Supreme Court?
Investigators, 2 judges, an immigration court that all said he was MS-13 and was removed from this country.
But you understand, that is you saying that. That is you saying that.
That is them saying that. This
no.
And law
that is you making that determination.
Against him. If you don't
the court has considered all that. The judge has considered all that to this court order.
It's got to be extremely discouraging to be one of your constituents. To see you fight for a terrorist like this and not fight for them is extremely alarming to me.
I'm fighting for due process, and that's under the Constitution.
Gentleman's
and you
time
should
has
fight too for
expired.
due process.
The gentleman's time has expired. I now recognize.
As the gavel fell and the hearing chamber descended into a tense silence, the echo of Congressman Dan Goldman's voice lingered, sharp, unwavering, and morally charged. "I'm not fighting for him," he declared, his words cutting through the air. "I'm fighting for due process." And with that, the exchange between Goldman and South Dakota Governor Kristi Noem came to a close. A clash not merely over one man, Kilmar Abrego Garcia, but over the very soul of constitutional power itself. In that brief, electrified moment, the chamber became a mirror for something larger, a reflection of the American struggle between fear and law, between the need for order and the duty of justice. Goldman's questions were not simply legal technicalities. They were reminders of a promise older than any party or president. That in the United States of America, even the accused, even the despised, even those labeled by the state as enemies, are entitled to the protection of process. Not because they deserve mercy, but because we deserve to remain a nation of law. Governor Noem's defiance, her insistence that law enforcement's word should suffice over a judge's ruling, was not just a political stance. It was a statement about power, about who gets to decide truth in a democracy. Her words, interrupted by Goldman's fiery, "If you would be quiet, I reclaim my time," crystallized an age-old question. When the government stands accused of ignoring the Constitution, who holds it accountable? The judiciary, sworn to interpret the law, or the executive, emboldened by conviction? The hearing exposed the fragile balance of those branches. Goldman invoked the Supreme Court, 9-0, a rare, unanimous voice from the highest court saying that due process had been denied. Yet here, before Congress, that ruling seemed to falter against the stubborn will of politics. In that tension, between the written judgment of the court and the spoken authority of an elected official, lies the heartbeat of the American experiment. It is in those collisions that the republic either renews itself or erodes. To the untrained ear, this was a spat about an immigrant, a court order, a bureaucratic failure. But to anyone listening closely, it was something more. It was about what happens when leaders forget that power, no matter how righteous its intent, is bound by restraint. When the executive begins to interpret the law for itself, the foundation of justice begins to crack, silently, dangerously, and always in the name of necessity. The scene grew raw as Noem turned accusation into defense, claiming Goldman's questioning was a betrayal, that he was fighting for a terrorist like this instead of for the American people. Her words, heavy with insinuation, echoed a familiar rhetoric, the weaponization of fear to silence the principles that sustain freedom. Goldman's reply, almost weary but resolute, cut through that fog. "I'm fighting for due process." It was not just a response, it was a line drawn in the sand, a reaffirmation of the idea that the law protects not the righteous alone, but the accused, the condemned, the outcast. And as the exchange spiraled, the viewer could sense the deeper tragedy, that even in the halls built to uphold truth, truth itself has become partisan. The Constitution, once the shared scripture of both sides, now brandished like a weapon, twisted to justify whichever moral high ground the moment demands. What was once a sacred oath has become a rhetorical tool, and what should be a conversation about justice has become a theater of power. In Goldman's fury, there was frustration, not just at Noem, but at a system where political survival too often outweighs constitutional duty. In Noem's defiance, there was conviction, but also the peril of certainty, the dangerous belief that moral right can supersede legal restraint. And in the air between them, something unspoken, the fear that America may be forgetting how to listen to itself. This hearing, like so many before it, will fade from the headlines. The names, Goldman, Noem, Abrego Garcia, will become political shorthand for whatever side one already believed. But beneath the noise, the story remains ancient. The eternal tug-of-war between justice and power, between law and authority, between the people's promise and the government's will. Each confrontation like this, in each chamber, under each flag, is another test of whether we still mean it when we say we are a nation of laws. And in that test, the question lingers, What happens when the government refuses to obey its own courts? When the Constitution is treated as a suggestion, not a command? When the machinery of justice bends toward the expedient instead of the right? It is tempting, in such moments, to pick a side, to cheer for the one who shouts the loudest. But democracy does not survive on cheers. It survives on the quiet, stubborn insistence that process matters, that no official, however certain, stands above the law, that the rule of law is not weakness, it is strength. Because when the state can strip one man of due process, it can strip it from anyone. And when due process dies, so too does freedom. In the echo of that hearing room, you can almost hear the voice of history whispering, "This is how it begins." Not with coups or decrees, but with moments like these, when we decide that justice can wait, that the Constitution can bend, that the courts can be ignored just this once. But the Constitution is not a suggestion. It is a covenant, one paid for in blood, defended by generations who understood that liberty demands discipline and that even our enemies are entitled to fairness under law. As the lights dim and the committee adjourns, one truth stands above the politics, the noise, and the outrage. America is strongest not when it punishes the guilty, but when it honors the process that decides guilt. That is the difference between a nation of law and a nation of men, and that is the battle still unfolding beneath the marble dome of Congress. For in the end, the fight for due process is the fight for democracy itself. This is Congress Chronicle. Stay informed, stay vigilant, subscribe, and stand with us as we keep watching the halls of power.